All right, welcome back, everyone. This week we are going to be talking about the courts. We are still under the module about how the criminal justice system deals with IPV. We've talked about how police officers deal with IPV, kind of some of the nuances between homicide and stalking. And then this week we're going to talk specifically about the courts. So, as always, if you feel the need to, make sure that you take notes. This is a cursory lecture, so it's not going to go over all the details, so make sure you read, but I will clarify some of the reading in this lecture. So, with that, let's go ahead and start. So, what are the role of the courts in the whole IPV process? Well, we know that um, domestic violence cases are not rare anymore. And in fact, the prevalence of prosecution typically varies between jurisdictions. However, we know that they're really common. In fact, your book is going to talk about specialized type of courts that address just domestic violence cases and family law type cases. Um, those programs show a lot of of great outcomes because they're kind of like one-stop shops where they have specialized teams and things like that. So make sure that you pay attention to that in your reading. But we see that we have high prosecution rates with domestic violence cases. In fact, you actually see high imprisonment and longer imprisonment rates for domestic violence perpetrators. So we, like with all of the criminal justice system, um, not every case that gets filed or petitioned will make it through the court process to be in front of a judge. There are high amounts of plea bargainings and sentencing negotiations that goes on um, with the prosecution and the defense that we typically see. But one of the things that we need to kind of clarify is this jurisdictional issue, and your book kind of talks about this, and we're going to talk about that next. So, we know that a jurisdiction is basically the legal term that defines the scope and authority of each court. So, we know that there are networks of courts across the United States that make up judicial systems. And so, um, in order for a court to hear a case, they have to have jurisdiction. Your book will talk a lot about the difference between civil and criminal law and how a lot of our work in family units, so intimate partner violence deals with family units, typically is handled in a civil functioning. Whether that be a magistrate court or something like that. But that is not something that a lot of people think of, but it is true. Like a juvenile court, its setup is really a civil court, um, unless there is a criminal component to it. Now, we have criminalized the act of domestic violence through various means, whether it be battery, assault, things like that. Then you run into concurrent jurisdictions where both the civil court and the criminal court will deal with the same instances, but in different ways. And so make sure you pay attention to that while you're reading. We know that courts' functions are similar from state to state, but the names are different, just like we talked about. Criminal law codes are concerned with civil or private rights and remedies. Um, Codes governing domestic relations belong to a body of law called civil law. So we just talked about that. So kind of remember that when we're talking about intimate partner violence and we're talking about a body that kind of governs domestic relations, we're talking about the civil law. However, when it when it kind of marries over then into the criminal side where we've criminalized the act of violence, then we are talking about criminal law. A criminal law violation can be tried in a court of general jurisdiction at the state level. State codes include provisions for civil protection orders when domestic relationships exist. But when we're talking about temporary protective orders and things like that, you're really kind of talking more about civil law and not criminal law. This is important. An overlap of criminal law and civil law is inherent in family violence cases. So it is almost guaranteed that you're going to have an overlap of civil and criminal law when we talk about family violence cases. Um, so um, you have to remember that the majority of like getting the protective order, child custody, support, things like that is all handled in civil law. The criminal law aspect and the jurisdiction of criminal law comes into play when it's the violence aspect. When those two aspects come together, we call that concurrent jurisdiction. So different courts are each authorized to deal with the same subject matter in a similar geographical area. Um, Guidelines on whether an offense belongs in family or criminal court vary from state to state. But we, in my experience here in Georgia, um, you can go to a superior court and get a temporary protective order, and superior court oversees some of that aspect under the or under the civil law as well. So, how do we determine the jurisdiction decision? Points that lead to the decision of whether a case belongs in family court or criminal court include the types of offense, the relationship of the victim to the offender, and the age of the perpetrator. So, there are three major court cases that I want you to be familiar with this week whenever we're talking about the courts and intimate partner violence. And really, this has to do with the Sixth Amendment protections uh, for um, for alleged offenders. Um, the Supreme Court has kind of dealt a blow in terms of domestic violence hearings and prosecutions under the Confrontation Clause of the Sixth Amendment. So we know that the Sixth Amendment allows um, the perpetrators to have a right to confront their accusers. And so that becomes problematic in the terms of intimate partner violence prosecutions because we know that fear is a driving factor for recantation and kind of avoidance of victims. And the Supreme Court has really kind of set their ground rules for how do we deal with this going forward. And it's not great news. So let's say that a domestic violence victim fails to show up for a criminal prosecution of their um, violent incidents. Their boyfriend beat them up, and they failed to show up to the criminal prosecution of that boyfriend out of fear for retaliation or whatever. Um, but that victim made statements to law enforcement that clearly show that that offender was the person who did it to them. The question is under the Sixth Amendment, could testimonial hearsay be admissible in court even when the victim wasn't there? Could their statements to police officers or their statements to a neighbor be admissible into that hearing without them being there? Because we recognize that fear is kind of holds them back. Well, in Crawford v. Washington, the Supreme Court says that testimonial hearsay is only admissible in one instance that has to have both prongs met. So the prosecution has to show that the declarant is unavailable, which means that the the victim was unavailable to be there, and that there was a prior opportunity to cross-examine the declarant. So just because the declarant was unavailable doesn't relieve that Sixth Amendment right to confrontation um, for the offender. And so both of those have to be met. Now, as with any law, there's some gray area. What does testimonial hearsay really mean? Like, what statements are considered testimonial or able to be provided as testimony? And so, Davis v. Washington and Hammond v. Indiana, both in 2006, so 2 years after Crawford, clarified what statements are considered testimonial. And that is circumstances indicate that there are no ongoing emergencies during the statement. So remember, there are some hearsay exemptions that deal with emergency incidents. So those testimonial hearsay statements don't fall under that emergency exemption. And the primary purpose of the interrogation is to aid the prosecution. So the primary purpose of those statements is to aid in the prosecution. So that that combined kind of clarifies what statements are considered testimonial hearsay. And with testimonial hearsay, we know now that it's only admissible in certain instances. So, as clearly as possible as I can kind of make this for you, testimonial hearsay is only admissible when the prosecution shows that the victim is unavailable and there was a prior opportunity to cross examine the declarant. All right. So now let's kind of transition into some of the players in court. Um, every court circuit typically has an advocate services. There are advocate services that are available to victims of domestic violence. And these advocates provide various levels of services. So they're there to educate the victim and kind of walk them through the process of court. They're there to assist them in kind of getting protection orders in the civil realm. They're there to accompany them to court and kind of explain what is happening. And they're really act as a liaison with the prosecutors and all of the other court um, personnel. I actually interned in my undergrad with the victim advocacy group, and my victim advocacy group was stationed in the district attorney's office, and so you got to kind of walk them through victim compensation and walk them through um, just kind of the processes, help them fill out different paperwork and stuff like that. So the most district attorneys offices have some type of what's called a victim witness assistance program that domestic violence advocates fall under that victim witness program, which we'll talk about victim witness assistance here in a minute. But specifically, um, some of those offices have designated DV advocates. In fact, the Conasauga Judicial Circuit, where I'm from, has an entire domestic violence prosecution team. So they have a dedicated prosecutor, they have a domestic violence investigator in the DA's office, and they have a domestic violence advocate whose role is literally everything you see on the screen. Um, there are video clips uploaded in Folio that I want you to kind of watch to kind of go through advocate services and the victim witness assistance services. So here's more about victim witness assistance. They work for the survivor instead of the court. Um, Victim witness is really like the umbrella, and domestic violence advocates fall under that umbrella. So victim witness really kind of deals with all victims, not just domestic violence victims. Um, but the purpose really of victim witness is to kind of walk that victim through this process and be the advocates for these victims. So, what are some forms of available relief that victims have, victims of domestic violence? Well, some common forms include restraining orders, temporary protective orders, are also what are they're called, exclusive use of the residence or eviction of a perpetrator from a victim's household, um, child custody or visitation. Um, Seizure of firearms and animal protections. So, a lot of the common forms you see are temporary protective orders, also called civil protection orders, which we'll talk about here in a minute. Um, Courts can request that the batterer leave the residence and the victim maintain exclusive use. And then in some this falls in civil law now. Child custody and visitation falls in civil law. And so um, there are some courts that will go ahead and grant temporary custody to the victim pending the outcome of everything. So everyone has typically heard of temporary protection orders or orders of protection. Your book calls them several different things. We've talked about them in several different instances, but essentially they're civil protection orders. And until recently, protection orders were restricted to protect crime victims and witnesses from harassment by defendants. However, now civil protection orders are available to survivors of intimate partner violence. These orders are generally referred to as restraining orders because their intent is to restrain the perpetrator from further abusive action. Civil restraining orders are important tools to for identifying and protecting domestic violence victims. And these are typically probably your first step in kind of remedying the situation with intimate partner violence when you seek some type of legal intervention is to go to the civil protection orders. Now, who can apply for a civil protection orders? Civil protection order can be applied for individually, or what is considered pro se, um, or the victim can get an advocate, and the advocate can help the victim kind of file. But there are certain things that have to be done. So the victim must make a written application for the order of protection. So this is called a petition. So the victim has to file this petition. The advocate can be there by their side to help them file, but the victim is the one that has to file the petition. The valid order must be signed by a magistrate, a clerk, or a judge authorized to issue the order. And it contains the name of a person who is under the order as well as the name of the complainant or victim. So your book kind of goes into detail about that it has to meet the relationship degrees of relationship um, set out with domestic relationships and things like that. But essentially, the victim has to um, file this petition or this written application with their court. They go before a judge and say, "This is what has happened to me. This is why I need an order of protection." Your book actually does a really good job kind of talking about what all goes into that petition. But essentially, it's demographics information of the victim, demographics information of the perpetrator, kind of description of all the issues at hand. So the victim can write, like, he hit me, and or she hit me, things like that. And so then a judge that goes either before a magistrate judge, some goes before superior court judges. Again, that's civil. So whoever will handle civil law in the jurisdiction. And then the judge will do a temporary protective order a lot of times. And that temporary protective order will be in play for a specified amount of time. And so that temporary order is given to the victim, and then it's got to be served on the perpetrator. From there, there will be a follow up hearing to take the temporary portion off of it and make it a permanent restraining order or whatever. Make sure you pay attention to the arguments about the stability of these civil protection orders that your book talks about. There's a lot of concern around follow up with victims, and not following up with these temporary orders, um, and things like that. So make sure that you pay attention to that in your reading this week. All right, that's going to do it for us for this week. I hope you all have a great week. As always, feel free to reach out if you need anything.